Consulting's webinar on UK law with regards to surrogacy. I have two very special guests with me here today. A family lawyer located in London in the UK, Andrew Spearman from a city law firm, and Cindy Wasser from Toronto, Ontario, who is a fertility lawyer. And so I'm going to do some quick housekeeping stuff first. If you'll see on the right-hand side of your screen, there is a question box. You can put any questions that you may have into that box, and they will be answered at the end of the presentation. You can send those questions just to the presenters or to everyone. If it is a private question you would prefer to have it answered anonymously, that's totally okay. There's also a chat box down at the bottom, and you can do the same and ask any questions or any comments that you have, put that right in there. If you're watching a recorded version, the presenters will give their contact information at the end of the presentation, and you will be able to get in touch with them if you have any further questions once you're watching. And everyone who is attending will be sent a recorded version as well, just in case there is a lot of information and you want to go back over and watch it again. So I'm going to hand it over now to Andrew Spearman.
Thank you very much. Very kind of you to introduction. Cindy and I were talking before we started this webinar, and we decided to do the journey in reverse. Isn't that right, Cindy?
Always backwards for us.
Best ways, because if you are living in the UK, regardless of whether you're a UK national or not, then you're going to end up dealing with the UK laws at the end of the process, and there's absolutely no point going through it if you can't actually get the recognition in the UK to be the legal parent that you intend to be. For that purpose, in the UK we have a process called Parental Orders, where we realign the parentage from the surrogate mother to either the intended mother and father or the intended father and father. It is something I have to reiterate to people, and why people sometimes are quite frustrated with the English process there, is that regardless of having gone through the process in Canada, you must still go through the process in the UK. It doesn't matter if you have a Canadian birth certificate, although it's very important to get one, as I'm sure Cindy will talk about shortly. But nonetheless, you must still go through the parental order process here. And I can't emphasize that enough. The consequences of not doing it are quite dire when it comes to succession law planning, parental rights, and actually being recognised as the correct parties. Not just for intended parents, but also for surrogates, to ensure that you're not captured inadvertently by the UK's laws for parentage still, even though you've dealt with everything in Canada. I'm going to rattle through the points quite quickly. If you've got questions or more detailed questions, then of course ask as we go through, and we'll pick them up towards the end. I'm very happy to go through any points again. For you to get a parental order, you must have a biological connection to the child, usually quite easy for you to get if you're going through the surrogacy process. But as a point of evidence that you need to get from Canada when you come back to the UK are letters from your clinic and contracts with your clinics to show that there is that connection and that it was your gametes that were used for the fertilization. Usually a very easy process. They're very happy to generate just a short letter after you finish to produce to the court here. We don't need to be interviewing your clinic in that way. We take it at face value. But that will then build upon your surrogacy contract, which is obviously the corner piece to the legislation that we have here, and that Cindy will be helping with you going through. It's unfortunate that in the UK it's actually a criminal offence for a UK family lawyer to be advising you on that contract directly, or to help facilitate the arrangement in any way. These webinars are great for that purpose because it's much broader, but nonetheless you must rely on the lawyer in the local jurisdiction, Cindy and her team, to make sure you get proper and full advice before you go anywhere near that jurisdiction. I can't help you, but you will come a cropper if you come back here and you haven't done it properly. Moving quickly on also, biological connection. Obviously, some parties will use an egg donor for the purpose of egg donation, where a same-sex male couple, for example, or a female couple who can't ovulate. It's important to keep hold of the contractual information and also have details of the costs and the money that you've spent there. the court will also examine to make sure you've not done anything untoward in the foreign jurisdiction. Obviously, in the UK, you can, or your surrogate's family and the clinic can come to an arrangement about the cost for that, up to £750 for expenses. But in foreign jurisdictions such as Canada, you need to talk to Cindy again to make sure that when you come back to the UK, I will be quizzing you about what that information is and how you've gone through the egg donor process if the contract is formed in Canada. Moving on, obviously we also need you to be in a stable relationship, or enduring relationship is the actual phrase. That's your marriage certificates and civil partnership certificates. They can very easily be produced by you. If you aren't in a civil partnership, that's not a bar to getting a parental order, but you will need to produce additional evidence to show that you are in an enduring relationship. I think my most recent clients produced holiday snaps, which is very enjoyable. I got to learn all about their holiday as well. But the basics come down to a factual exercise. There's no right or wrong answer. In fact, actually, living together doesn't necessarily prove you're in an enduring relationship. It's just a bit of an easier one to go down. You can't at the moment apply for a parental order if you're single. Single fathers or even single mothers can't apply for a parental order in the UK. So any parties going down that route already really need to come and speak to me quite quickly to see how we can remedy that and what the options might be. There is a change in law in the pipeline. If you've researched it, you'll find that there was a declaration of incompatibility against the European human rights. Unfortunately, as you can probably imagine, the Parliament's been a little backlogged with getting through some other statutory instruments at the moment. We're not expecting it until the end of the year, even though it was promised at the beginning of the year. This is causing quite significant concerns to us as practitioners, but you really need to be considering your position. And surrogates as well, if you're watching this, you need to be very wary of single intended parents coming to you if they're UK residents. Moving on, we've got a 6-month time limit. You must make your application within 6 months. Evidence for that obviously is the birth certificate for the birth, and 6 months from the date of birth, not 6 months and 2 days, not 6 months and 1 day. 6 months is your limit. There is a very small window for you to have an adjustment on that, but it's not one that somebody with a good planning who's come through lawyers should really be relying upon at all, to rely on the mercy of a judge letting you be recognised as a parent. You've obviously got as well that one of you is domiciled in England and Wales. If one of you is domiciled in Scotland, then I'm afraid you'll have to speak to a Scottish lawyer about that. But your domicile in the UK doesn't necessarily link strictly towards your nationality. If you're a foreign national, you can still be domiciled in the UK. We're looking there for a permanent intention to remain in the UK and have your base here. Again, that's evidence. Your job, your house, your family, your support network. It's evidence that you'll be able to write to me, and we'll go through in piece by piece. It's the area which the judges at the moment are quite hot on to make sure that nobody is travelling to the UK to benefit from our parental order process without actually having the right ground. It's called forum shopping. You've obviously both got to be over the age of 18 as well. You must be adults. You must be able to consent, and likewise with your surrogate must be an adult and consent. I know that Cindy will speak likewise, but again, your contract will be evidence for me for that purpose. I don't require additional documentation. If there is a question about them or a question about their age, then we can go into that in more detail. Not usually a controversial one though. One of the most important parts of UK surrogacy law is that the surrogate has consented to your parental order of their own free will. This means signing off a particular form for the UK courts no less than 6 weeks after the child's birth. The consent form is just an A4 piece of paper. It's very straightforward. It kind of does what it says on the tin. It's important to make sure it's signed. It's one of the only documents that the English lawyers, we haven't managed to get around, because that fundamental tenet of your surrogate's consent to the whole arrangement is still a tenet of English law. Therefore, you're talking to Cindy at the moment. It'd be really good to hear from her how she helps you, as she will. But you must be responsible for it as well. you must look into the agreements and the contracts. You must communicate with your surrogates and make sure they're aware that after birth, the arrangement doesn't just stop. You have to continue the process in the UK, but this consent form is really quite vital. You're unlikely to actually still be in Canada, and most of my Canadian clients aren't at this time, and so you must rely on other parties to help you get this done. We can give the copy of the form well ahead so that your surrogate is aware of the form, what it looks like. Again, not complicated. Get it signed, get it notarized, and get it returned. Within the contract, again, the free will aspect is quite important to us. That comes into two remits, both about costs. One is that you aren't to pay your surrogate to sign that consent form or pay for her to hand over the baby. Therefore, your surrogacy contract can't make reference to making payments to them in compensation for signing those consent forms. Likewise, you can only pay reasonable expenses to your surrogate. Now, this is one of the benefits, I think, of actually going to the Canadian jurisdiction. One of the absolute pleasures I've had in dealing with Cindy through this is dealing with the Canadian jurisdiction. They have a much better grasp of what reasonable expenses are and what compensation isn't. To our mind, the UK courts are still, the English courts are still quite strict, and you must open up every payment that you've ever made. I tend to start from the basics and work our way up, and the evidence is based in your surrogacy contract to start with, but also your bank statements. If you use the right agencies, then they will also be able to provide to you a breakdown of all expenses if you've used a trust account, and it should be itemized going through each one. Like I say, running through those common expenses, the ones I would expect to see, obviously fees to your surrogate for her costs for travel, for food, for maternity wear, for costs and expenses you'd expect for her hospital appointments, costs for living expenses, and also for third-party expenses. So I'm expecting to see that you have paid for her to get independent legal advice on the document before that she has signed it. I'm expecting for you to have also got, if she is married, for her husband to obtain legal advice on the document, because he is also a party to our proceedings. In the UK, the consent must also come from a husband, as well as the surrogate if they're married. It's not, in my experience, a huge problem, but again, when you're looking at the consent forms in your surrogacy contracts, just remember that the husband, if they are there, should also be a party. Third-party expenses run on from there, or your expenses are also examined, not just the surrogate's expenses or payments that are made for the surrogate's benefit. So here we're looking at solicitors' costs. Yes, Cindy, we'll be coming back to your costs. My costs, we'll be going through the clinic's costs, your agency costs, disbursement costs, retreat costs, management fee costs, pretty much everything from start to finish. Is possibly the largest exercise that my clients have to do, and the largest amount of time that I spend with them is going through their costs. The UK and English judges are very, very diligent in their examination of these costs, and therefore you have to be 100% certain as to what you're paying and what it's for. I say to my clients as a common piece of advice, it is not going to be the CFC, it's not going to be Cindy, it's not going to be me, it's not going to be anybody else other than you who are sitting there before the judge explaining what those expenses are. You can rely on third parties, and obviously stage advice you get from those in the Canadian jurisdiction is important to make sure that you're not going completely off the deep end. But nonetheless, you really have to keep a close scrutiny yourself and be able to justify to a court at the end of the day why you approved those expenses. Not a third party, it is your approval that is required. So in looking at that, you might be looking for confirmation of those costs. Receipts should be provided, or a monthly breakdown for those sundry expenses. Each surrogacy arrangement is slightly different, and what you expect and what you can get could also be slightly different. It really depends on your surrogate, where they are, what kind of expenses you're paying. Some are easier to examine than others. We're not saying that we're going for every penny or every cent that you spend. You really should be able to identify the main costs. And funnily enough, the judges in England and Wales have done this quite a few times now, that they're expecting certain common costs to come up. There's no point in pretending that they're not there. There's no point in pretending that some costs may look a bit larger than maybe you were originally expecting. They might still be very normal for the jurisdiction, Just provide the evidence, give it to us, and let us work through it together. The final 2 points that I tend to bring up and usually submit as evidence in your parental order application come down to confirmation from your Canadian lawyer. Confirmation that you have actually followed the due process in Canada. The English judges are still a little bit paternalistic in their view of the international law, and they want to make sure that you're not taking advantage of a foreign jurisdiction. Therefore, as I said before, have you applied for the birth certificate properly? Have you followed the Canadian lawyer's advice? Have you followed the Canadian jurisdiction's general advice and ensured that you've taken all possible steps to remove the surrogate mother from any responsibility in Canada? Admittedly, when you come back here, apparently it doesn't quite matter because we have to go through it all again. But, you know, we have to at least respect foreign jurisdictions. A letter from your lawyer will sort that out. Confirmation that all the process has been completed, there are no further steps for you to take, and it's very easy for you to get. Don't overlook it. And the final one is actually yet another form from the court that we send out much later, and this is a confirmation and acknowledgement that the court proceedings are taking place. So after you've got all your evidence together, and after you've submitted the applications to courts, and after you've got all those statements and receipts and all those documents together, and we finally get the documents to court, and the court starts processing it, appoints our court reporter, you'll then get this acknowledgement that then has to send out to your surrogate to confirm not that just that she's still consenting to the parental order being made, but that she's aware of the court proceedings, and that she's aware that she's allowed to attend and make representations at these court proceedings. Any contractual obligations, any way to bind her against that, more commonly seen in the American jurisdiction, but nonetheless aren't valid, aren't enforceable in England and Wales, and we won't recognise them in the contract either. In most cases, I'd probably say 99.999% of the cases, of course, your surrogate doesn't really want to travel all the way to London to have it, even though I'm sure she'd love the holiday. Nonetheless, realistically, I don't think you're going to pay for it either. There's no need. Wonders of Skype, wonders of webinars like these. Our CAFCAS officers can speak to your surrogate if absolutely necessary. Usually the evidence provided means that's not necessary though, so we're all fine. The court process is very straightforward, even though unfortunately it does take a little while at the moment. We've got a bit of a backlog even in the UK courts at the moment. But there will be a court reporter appointed. They'll meet with you. They'll make sure you fulfill the statutory criteria. They'll have gone through the statements that I will normally prepare with you. They'll have all this evidence to make it more streamlined for them, and go along to the first hearing, and hopefully there'll only be one, where the court will be able to make that order for you, be recognised as parents. If you're British nationals already, then the British Nationality Act will allow you to register for British nationality for your child, stepping from there. But you'll see that everything really comes back to evidence, making sure that you can prove that your surrogate was given independent advice and understood the contractual terms and wasn't taken advantage of. The fundamental thing I would like to leave you with, I'll come back after Cindy's spoken, but your relationship with your surrogate is by far the most important aspect of this entire process. This is a wonderful woman who's giving up their time and body for you to do it. Don't underestimate it, because any problems, any queries, or any concerns the surrogate has, the UK courts will support her in those concerns as well. Make sure you follow that process, make sure you treat her with respect, and make sure you follow the guidelines that Cindy and the colleagues in Canada do. You can't come back to an English jurisdiction and expect to be supported. On that note, on that happy note, I'll pass you over to Cindy.
Thank you, Andrew. I think that was really helpful, and also for me the way it was laid out. So I want to start off by saying that anything Andrew Spearman wants, I can give him. And anything. It's been my pleasure to work with Andrew now on a number of files, and my clients always report back saying it's wonderful for them. So I also would like to start at the end of the Canadian journey, just before you board the plane to go home and see Andrew. In order to leave this country of Canada, you will need a travel document for yourself as well as for your new baby. And usually that travel document is a passport. So you need to obtain one for your baby to leave. The quickest passport to obtain in Canada is the Canadian passport. And your baby is entitled to one because any child born on Canadian soil is automatically a Canadian citizen. You don't apply for citizenship. It is the baby's right at birth. You do apply for the passport. So I want to talk about how you get that Canadian passport and the timing so you understand how long you have to be here for. What you need for a Canadian passport is a birth certificate naming you as the parents. If you're not the parents, then the parents are the ones who have to apply for it. So if you've left the surrogate on the birth certificate and not bothered to do the order here, she is an applicant for the passport and will then have to give you a notarized letter allowing you to travel with your baby. Much the same as if I were to take my children on a trip without their father, my husband has to notarize a consent letter for me to take them. Now, the other thing you need to get a Canadian passport is someone else to sign off saying that they know you and this is your baby. We call that a guarantor. The guarantor signs the back of the picture of the baby. That is very challenging to get, by the way, and the most challenging thing to do in this entire process, by the way. And then the guarantor says that they've known you for 2 years, and they're swearing this. If you don't have someone in Canada who is a guarantor, and they must be Canadian and holding a Canadian passport, then there is another person who can do this for you. And that person is a declarant, and that is usually the lawyer, or me, or your lawyer wherever you are in that province or city. The declarant, if you need one, swears that you are who you say you are and the baby, and then the application can go to the passport office. If you use a declarant, you must also provide the name of 2 references. And those would be anybody who can say, yes, they know you, you are who you are. If you choose your references to be someone back home in the UK, then your passport application will go to your embassy here, where they will make the long-distance phone calls, because for some reason, Passport Canada claims they don't make long-distance calls, which I don't believe, that they don't have a free plan. But that's what will happen, and that will naturally add a few days. If you name 2 Canadian people, then Passport Canada may very well call them for you right away. So if you can get a guarantor, which most people will use as their surrogate, or somebody at CFC or whatever the agency is because you've been working with them long enough, then that is the fastest way. And you take your passport application with the birth certificate all filled out to a Canadian passport office. And you go in person. In any major city, there will be an office. If you choose to mail it in or courier it in, you will wait 3 or 4 weeks to get your passport. If you walk in, take a number and wait, you can come back the next day and pick up your passport, 24 hours. If you are fortunate enough to be near Toronto, where I am, there are 2 passport offices, and the one up the road through that window offers an emergency service of 3 hours. Hours, I said it, hours. So that is for anyone who can show up with, in addition to all the forms, their airline ticket saying we're leaving that day or the next day, and they will give you that passport in a matter of hours. So that's a real bonus. That's why I say the Canadian one is the fastest one to get. Most other countries will take 3 or 4 weeks to issue a passport to you. So if you are planning to save up all your holidays and parental benefit leave and stay here, that's no problem. But you will need that to leave the country. So now let's take the next step backwards. How do you get that birth certificate? In Canada, the issuance of a birth certificate is within the jurisdiction of each province. So every province in Canada has a vital statistics office that says all marriages and divorce, all births and all deaths must be registered. So you must register the birth and apply for the certificate. How do you get a birth certificate if you didn't actually give birth to the baby? So each province has its own method of doing that as well. And the time it takes to process the birth certificate will vary from province to province. So it's very important to go back to picking the right providers. Your agency, your legal counsel will know these issues and will guide you in the selection of a surrogate who resides in a province that will be able to grant and issue a birth certificate relatively quickly. And those of us in the industry who know this would tell you that there are 3 or 4 provinces that are the best for surrogacy for foreigners. And those are British Columbia, Alberta, Ontario, and Nova Scotia. In those provinces, you should be able to go home between 2.5 to 3 weeks, generally. And that's if everything goes well. There's no sick baby, there's no delay, couriering something, you know, some judge didn't get sick in the courthouse, didn't shut down, something like that. But if everything goes smoothly and quickly, that's the time frame. So I want to talk about the various differences in those provinces. All of them, first of all, can give your lawyer in the UK all of the things that Andrew says you need. In Nova Scotia, the process is slightly different than the other 3 provinces. So in Nova Scotia, the surrogate is on the initial birth certificate, which is issued in 2 weeks. So she has to apply for the passport for you and give you consent to travel home. While you're at home, the lawyer in Nova Scotia goes to court to obtain a declaration of parentage, naming you as the only parents and saying she is not. And then a new birth certificate is applied for, naming you, which will then be sent to you back home. And for some people, that's fine. For others, it isn't. But it works just as well if that isn't a problem for you. In Ontario, Alberta, and British Columbia, there are 2 methods for getting that birth certificate. One is the Statutory Declaration. It is new in Ontario and just started in January, and we have another webinar all about them, so I'm not going to go into great detail. But in essence, the Statutory Declaration is an administrative process whereby the surrogate signs a consent saying, I had legal advice, I entered into a contract before the transfer, and I consent that these should be the parents. And the parents sign something the same. And they apply for a birth certificate, and they fill out a form that's called the Statement of Live Birth. In some provinces, it may have a different name. But in essence, it says, we are applying to be the parents. And that is processed by the registry office, and the birth certificate is issued. In British Columbia, that can be done immediately, and the birth certificate may be issued in about a week or so. In Ontario, the rule says the surrogate cannot sign the consent until the 7th day after the birth. So we wait a week for her to do that, but the law says very clearly you are recognized as the parents from the moment of birth. And then we file it, and we're getting the birth certificates. Generally, on average, or more than average lately, they're being delivered to my office on the 14th day after the birth. And I'm sending my clients to the passport office, and I'm seeing people go on a plane day 16, day 17. Some of my clients are actually changing their flight and pushing it forward so they can go home earlier than they anticipated. And that's really amazing. In addition to the statutory declaration process in British Columbia and Ontario, we have a court process, much like Nova Scotia's, and it is the only way to do it in Alberta as well, where the lawyers go to court and say to the judge, please declare these people or this single person the only parent, and declare the surrogate, and if there's a partner, the surrogate's partner is not a parent, positive and negative order. And please order a birth certificate to be issued accordingly. As I said, Alberta only has the court process, and Alberta requires that at least one person be genetically related to that child. In British Columbia, the rule is that whoever was on the surrogacy contract or agreement with the surrogate must also be on the birth certificate. So if for some reason you only want to name one of you, which I don't think is an issue in the UK, but could be for other countries like France, that could be a problem if both of you enter into the surrogacy agreement. Ontario has no such stipulation. And so that's basically how you get your birth certificate and you get your passport and go home. What do you need in order to have that surrogacy agreement legitimate so that you can get the birth certificate? So now, at the beginning of the process. Very similar to what Andrew has described, we put in the surrogacy agreement. We like it to be something that outlines all the rights and obligations between the parties so that you're talking about it now, not when someone's 6 months pregnant and under the gun and feeling pressure, and certainly not when your surrogate has started medication and may be affected by the amount of hormones in her system, and you and she by the pressure that envelops with that process. So we want to do it early on. But we also think it's a pretty good idea to ensure that the medical screening is done in some cases, and in some cases you may not do, you may want to do it beforehand. So that one is up to you to decide on each and every case, depending on your clinic and what's involved in the medical screening. The surrogacy agreement is generally an unenforceable document in most provinces of Canada as to everything but parental rights. The one thing that's enforceable is the intention to parent. And in almost every province in Canada, and certainly the ones any of you would be involved in, the intention to parent is the rule of law, not the genetics. If you intended to be the parent, you should be, except for the one caveat of Alberta requiring one genetic link. So you can be single in Ontario, in Alberta, and British Columbia, as long as you are the genetic link. You can be not genetically related in Ontario and BC, as long as you intended to be the parent. So we make that clear in the agreement. We also ensure, because it's mandatory to get the birth certificate, that the surrogate has independent legal advice. That means your lawyer cannot act for your surrogate as well. She will be referred to another lawyer. And it is perfectly reasonable for you to pay the legal costs involved in that. When you apply for the birth certificate, I mentioned that the surrogate signs a consent form for the Statutory Declaration. If it's a court-ordered one, she would also sign an affidavit and a consent form saying that she consents to this order being made. So it would be very similarly worded to what your lawyer would do for you back home. And we can even attach documents from foreign jurisdictions, so Andrew can send me a blank consent form, a blank affidavit filled out that we can attach as a schedule to the contract with the surrogate, so that when she has her independent legal advice today, she can review the documents that you will present to her next year to sign, and therefore shouldn't need another lawyer at that time. But of course, we build into the contract that that is always open to her, and of course, we would take care of the cost of that, so that she knows everything that is going to be coming her way later. There are a couple of things that we also add into the contract in Canada, which is a list of the expenses. Most of the lawyers here will do that because we also feel that talking about money with the surrogate, even when it's an altruistic process, is just really not great. You want the relationship to be one about the baby, how she's feeling, how the baby's growing, how excited you are. When people start talking about how much it costs to get to the clinic or what the grocery bill was, it starts to put a chill on that relationship. And so again, it goes back to working with a good agency that will take care of that for you. But we like to have it all set out during the negotiation process so that it doesn't have to be an issue later. And when we've presented the contracts to the judges, when we've gone to court, they've seen what those amounts are, and they've generally accepted them. We've not heard of any cases where a court order was not granted because of the list of reimbursements. The current state of the law in Canada with respect to reimbursement is kind of open-ended. The law says thou shalt not pay a surrogate or a donor, but they are entitled to reimbursement. And that law came out in 2004, and they said within 6 months we would get a regulation attached to that law with the list of expenses. We're still waiting. And that was 2004. And then last fall, our amazing government as it is, announced that it was time to actually look at this. And should we bother making this list, or should we simply decriminalize the whole payment thing? And they reached out to all the stakeholders in the industry, so the lawyers, the clinics, and the agencies all made submissions by the end of November to the Minister of Health, and most people said, decriminalize, of course, but just in case, here's a list of the expenses that we've been doing anyway. And then things kind of changed politically in the US, so our government has been having to deal with other issues and priorities involving trade agreements, and it's been on hold. But we predict that that's the route we're going in the next year or so, with a big legislative change here making it even easier. That's not to say that it will become commercial. It will still likely be an altruistic system, but with an open-endedness about reimbursements without criminal sanction being attached. So the only difference is, if you did by chance give her too much money for yogurt, you won't be subject to a criminal penalty, which nobody's been prosecuted for anyway, and that makes reasonable sense. I think it would still be wrong to buy your surrogate a car. And if a surrogate said, I got a trip to London after I gave birth, it may very well be a gift that's illegal, or it may be because she had to testify at a hearing, in which case it was very reasonable. So you have to always know why something was paid for. The other thing that Andrew mentioned is that if the surrogate has a husband in the UK, he too would have to sign the consents and be part of the UK hearing, so to speak, through that. Well, in Canada, there is no legal requirement that a surrogate's husband be part of the process, because a woman has the right to control her body and therefore does not need his permission or her partner's permission to do so. But there has been always a policy amongst the clinics that a husband needs to be part of the process. He needs to be tested for disease, obviously, and he needs to have psychological counseling to help to make sure that she has the support in place. And so it's been the policy of most agencies to advise the surrogate that her husband or partner must be part of the process. And so if we know that one exists, we will always put them in the contract. And we will always ensure they are part of the independent legal advice part, because we think his consent to this process is important so that she has the emotional support and doesn't back out halfway through because she's getting divorced because her husband's mad about this. So there's no legal requirement, but there's a very big practical one. And then if you are a UK client doing this, we now know it's fundamentally important and must be. So your agency has to know these things, and that's why we do these webinars, so that the word gets out in advance so that we don't have a big mess to clean up afterwards. Now, the donor situation is also very interesting in Canada versus the UK. In the provinces that I've mentioned that you would likely do your journey, there is also legislation that speaks to the parental rights of parents and donors. And it says a donor is not a parent, unless intended to be. So you may have an egg donor and the father, intended father, is a sperm donor technically, but you're intended to be a parent, so you are. But your anonymous egg donor or even a known egg donor was not intended to be a parent, has no parental rights under the law. but we are not allowed to compensate them. Whereas in the UK, I understand now, you can actually reimburse the donor and then a little bit of compensation with the maximum amount. So rest assured that if your donor is in Canada and you're working with an agency and reimbursing her, that should be more than good enough for UK standards, because we're not compensating them for anything. And we don't need to refer to them in any court order for parentage. Some of the judges in Ontario have simply indicated if you're going to court here and you're doing your affidavits for the parentage application, they would also like you to swear that you neither paid your surrogate compensation nor your donor. But they otherwise don't care about including her in the application. In fact, made it very clear they don't want the donor to be part of the application. And she doesn't have to be, because in law, she's not a parent. The surrogate is a part of the court application here. Generally, she is named as a respondent with you as the applicant. I've recently been asked on behalf of Spanish clients, the Spanish consular here is asking whether we can actually name a surrogate as a co-applicant, so she has more stronger rights with the application. And we've never had to do that, but we see no reason why she shouldn't. And I'm just waiting for a call from my judge to get it pre-approved. The lawyer in Alberta doesn't see a problem, but it may be in British Columbia. So we could even say the surrogate has a greater right in this court application here, which I think would really impress the UK judge, from what Andrew was saying, by saying she's really a part of the process. The surrogate is a co-applicant. Then they may even like that. That is something to look forward to in the future. I certainly like the idea of giving her that stronger presence. We don't need much proof of your relationship here. You will be entering into an agreement saying, you know, where you're from and that you're of age. You have to be over 18 to have to be the recipient of an egg donor. Oddly enough, there is no age limit for you to have a baby here, or age minimum, but the surrogate has to be at least 21. So we do tend to put in the contract that the parties are over 18, and that's more for people going to other countries with that contract. It's not so important here. And then, of course, the clinics will demand an age minimum, and I don't think they would treat you if you're under 18. But for the surrogate, it's a minimum of 21, and the clinics all want to see that a surrogate has children, preferably finished. But you know, that's okay if she's not. But they won't take a surrogate here who has not had a child yet, and that's really important for you too, because it will alleviate any emotional issue that you might be wondering about, you know, about her giving up a baby. Surrogates have a great deal of psychological screening and emotional support from their agencies and groups and surrogacy retreats, where they come to understand that it's not their baby. This is something they're doing as a gift, and they might have some hormonal issues that would be natural, but it isn't an issue of regret and I've given up my baby. It's a fundamentally beautiful thing that they go through here. And they are so proud to be doing it and helping. It's really beautiful. So those are most of the considerations here from the legal perspective. In Canada, it's a pretty easy thing to do. We will basically make anybody a parent who wants to be, and we do it in a very safe way. We have really good health care. We have very stable laws, and we have a really good immigration policy so that it should be recognized by your courts. We are Commonwealth. We are your children who grew up inside independence, but we are Commonwealth. And so a lot of people from the UK are finding it really easy. And I think that's really all I need to address. Andrew, do you have any questions of me before we
No, I think that's all clear from my perspective, and obviously from all the clients I've worked with, who have come to me from you, it's always been a very straightforward process for us to then pick up the baton, a very smooth transition. It's always the way I normally work is to have a meeting with them, intended parents first, and then have them have a chat to you. But at the same time, the clients that have come to you first and then come to me the other way around, it works absolutely in synergy. And what I understand, and even some parts I've even learned today as well. It's been very exciting to hear about the single persons on the birth certificates. You're right, I don't think we would have any trouble at all with that here, mainly because we're going to reissue a new birth certificate anyway, in fairness. So the process that you've gone through to get there is more important than the end product. The birth certificate is the evidence that we would want. And I think I would just pick up, not necessarily a point, it's just to echo your sentiments about the husband, actually, and having a family around them. My contemporaries sometimes advise clients that actually finding a single surrogate, having had children before, is preferable because of the added hurdle we see in the UK of having to get the husband's consent. I think I traditionally take a different view in that the same one that you've just advocated, Cindy, that a surrogate who has a family around her and a husband to support her through the process, who has been through the journey and can have somebody to help her through those times when intended parents aren't around, is probably more important to help the surrogate through those steps together, and you have a much more stable journey as a consequence. But otherwise, no.
What I often see on the CFC blog is surrogates now having separate blogs of their journey with their parents that I'll be invited to, and I see them talking about, oh, had a tired day today, couldn't move, couldn't get in the kitchen, love my partner for doing everything, and that's pretty good. Although single women who are surrogates also have different support people. They have family and close friends nearby who can do that for you. But it's also a monetary consideration for you as parents to think about. If she is having that day of morning sickness that can go on for 3 or 4 months, and she does need that extra help, well, and there isn't someone that close by, then you will likely be paying for extra housekeeping and home care, child care while she's being sick for you, for your baby. So it's wonderful to think about. But we don't have a problem getting husbands to sign affidavits, consent forms, or anything. I mean, sometimes it's just a timing thing of work shifts, but we get it done without any difficulty here. They're on board. And if there's any issue being spoken about that, it's difficult to get husbands, I'd say that that's a legal myth in Canada. Not if it's done through the right agency, the right providers, everything is good.
And with the right lawyer, of course, Cindy.
Thank you. So, and Andrew said something at the beginning of that about referring to each other for advice. It is always my practice, and that of probably any lawyer here in dealing with international clients, that you seek counsel in advance to know whether this is going to work for you and to know what you need to do coming home, because we want to make sure our contract has everything in it that will work for you when you get home. And we also don't want you to worry about things like, well, I've heard in the UK expenses are a problem. And, if you talk to someone at the beginning, you will find out that it's okay. The expenses we have are okay. And that just relieves your anxiety level too. And so, this webinar is perfect because people can use this, but I'd still suggest a call to somebody to get some advice. And Andrew, I know, will do this for you. And it's a really good idea at the very beginning. Oh, there was one other thing I didn't raise that we should talk about, and that's the wills. Now, if you're carrying your own baby and you die early on, the fetus, unfortunately, is going with you. But if you both die, or a single person you die, your surrogate continues to live carrying the fetus. And so you need to have a will in place. And although not a legal requirement, it's really important for the surrogacy here. Surrogates will demand it. And apart from what a will would normally have in it, we want to see that it references the surrogate in Canada carrying your baby, and that it allows for your estate to continue its obligations to her under the contract you have in the agency. And then the most important piece is that you've named a guardian. And you need to tell the guardian that you've named them. So you need to, I always tell my clients, open a bottle of wine and have this discussion of together as who is the best person to raise your child. And that's a tough one, but you can come to terms, but then you must tell them. Because if, and I should say it hasn't happened where both people die and the surrogate's pregnant, but if it happens, we want to be prepared. Your guardian would come here, and under the laws of the provinces where you would do this, they actually stand in your shoes to get the application. They are not the parent. You will be. They just do it all with us as the guardian. And so the birth certificate will be issued in your names and the passport with you as the parents. And the guardian can then fly home with the baby with all of that, naming them as the guardian, and do what needs to be done. So the other thing you need to do in the UK before you start the program is get your wills in place, and you need to have a UK lawyer.
Yes. I mean, to pick up on that from you, Cindy, I mean, fundamentally, a will in the UK is absolutely necessary if you're having any family planning. But even more important when it comes to families that are utilising the Human Fertilisation Embryology Act in the UK, it comes down to not just the payment of expenses specifically for contractual obligations that your state will invariably continue to pay anyway, but making sure it's quite explicit for your surrogates' peace of mind to make sure that they are going to continue to be reimbursed for their reasonable expenses. But actually, because until you've got your parental order, the UK, or the English law in particular, doesn't recognise you as the legal parent to any child born to a surrogate mother. As a consequence, your estate, if you gift in your will, estates to your children, which most couples do. They give everything to the partner and then down to their children, or partially to their children and the rest to their partner, depending on your tax planning side. A whole other webinar to go into there, but nonetheless, your estate won't actually provide for the children of that surrogate in the UK because they're not your children until you get the parental order, as far as English law is concerned. Problem for us. You must change your will to redefine the definition of children to actually capture children born through a surrogate.
Great. So I think we've covered everything, and we can open it to any questions that appear on the chat line now.
Yeah, so we do have a couple of questions, so I'll just go through them one by one, and then whoever wants to answer can. So the first one here, CAFCAS website stated that if a foreign court approves an adoption or parentage, this will be recognized in the UK. How does the new Ontario law around parentage impact on the UK parental order process?
I think that's for both of us. So let me start with the Ontario law. Under the legislation, you are automatically recognized as the parents and can apply for a birth certificate administratively. If that's not a court order. If a country requires a judicial order, then you would still go to court in Ontario and get that order from a judge, which you can send to your country's authority. But Andrew, you can answer whether it's required in the UK to have a judicial order as opposed to come home with a birth certificate.
No. I was about to say, from my perspective, that question has two strings to it, which perhaps is, I'm not sure with the question itself, but picking up from what Cindy said, you don't require a court order itself. What you require to do is follow the full possible process to be recognised as parents in that jurisdiction. So if you have followed the due process in Ontario, and the due process in Ontario provides for statutory declaration, then the UK courts will pick that up. Because the UK courts are looking for due process, because we're going to give you a new birth certificate anyway. I mean, only then will we recognise you as legal parents. What we're concerned about is an abusive process. In contrast to that, I don't know whether it was alluded to, and forgive me for going off on a tangent, but it's certainly why I picked up on that question is about whether the due process in Canada in getting a court order assists you in getting recognised as a legal parent. Faster without needing a parental order here, perhaps. I'm not sure whether that's it, but no, in the short order, the UK will recognise foreign orders. That's part of the Hague Convention on Children. The problem is that actually it's the public policy arguments that parental orders introduced. We've never recognised parental birth certificates and court orders that grant parentage based on a surrogacy arrangement. Because of your domicile in the UK, you can't escape to a different jurisdiction and have a child and then come back to the UK and expect to not have followed our laws. I'm not sure whether that's exactly the question as asked, but I'm going to give that for completeness.
And if I could just add, because you mentioned the Hague Convention, it's important to note that Canada never signed that until last month. So, and there were a number of reasons why, and I won't speak to them because I'm not the Minister of Foreign Affairs, but it wasn't anything to do with surrogacy. That convention has a lot of stuff in it, and the reason why they've decided to sign it isn't necessarily about surrogacy, but because there's a lot of stuff in it. But now we are. So I would think that that would only make surrogacy recognition in other countries of Canada a little bit better.
Great. Okay, next question. Can you confirm how many hearings on average are necessary for a parental order to be granted? I'm assuming that's in the UK.
I was going to say I'm going to field that one. That's too mine. If you have an efficient process with a solicitor who understands the High Court, because you're always in the High Court rather than in the local family courts here, because of the international element, there should 2 is the average. You have an initial directions hearing where you have additional reports filed, evidence concerned, and then with a time to remedy any problems, and then a final hearing to grant you a parental order. In my experience, especially with the Canadian jurisdiction, is that there aren't any problems, and if you have somebody who can make an application to the court ahead of the first hearing, the judges will grant you a paper application and dispense with the first hearing, therefore saving a lot of time, a lot of money, and a lot of effort getting to a court for a second time. If you have a case that is maybe more complicated, your surrogate has gone missing, or surrogate doesn't consent, or any issue at all, you can expect more than 2 hearings, I think. Usually I have one not in the Canadian jurisdiction, but another jurisdiction that required 4 separate hearings. And it was really wholly unnecessary at the end of the day, but I wouldn't inflict that on anybody by choice. So I say 2 is fair, 1 is really what you should be pushing for there.
Great. Okay, next question. Can you clarify whether British nationality can pass on to your child if the non-genetic intended parent is British and the genetic one is not British?
Right, yeah. Okay. Following that question, yes. Get your parental order. The British Nationality Act was amended with the HFEA 2008 to then follow down not just the genetic parentage, instead that different nationality progression comes through a number of different ways. But the one I think you're referring to is overridden by the parental order, and therefore makes it by default in there. I think I've got my head around that one properly.
Yeah. Okay.
The non-genetic can pass on by descent.
Yeah.
Okay. If the gamete donor is not a UK citizen but is a legal resident, but the partner is a UK citizen, how does this affect the baby's entry into the UK, the parental order, and the ability for the baby to acquire UK citizenship? So that's, I think, the similar question. That's the same question we just had, I think.
Sure.
Yeah.
Okay, so I'm going to take them in broad terms rather than specific terms. Return to the UK, you'll be travelling on a Canadian passport anyway. So essentially your baby's a tourist coming for a holiday for a period of time, which is absolutely fine. That's what most children do, while we're dealing with the parental order. The travel documentation, therefore, is based both on your destination country and where you're coming from, making sure you can leave the Canadian jurisdiction properly, which Cindy was talking about before. Return to the UK, most immigration officials are absolutely fine with the process of surrogacy nowadays, particularly in Heathrow and Gatwick. Not that I'm saying anything bad about the other London airports or other UK destinations, but given the fact they hoard most traffic coming through from international jurisdictions, their immigration officials are well trained to pick up on surrogacy arrangements, whether it's a biological connection, non-biological connection, however you do it, as long as there is a biological connection to the child for one of you. You've got your Canadian birth certificate in hand, you've got your Canadian passport at hand. I've not found any trouble with re-entry into the UK, provided you're organised. And that's where, just talking and doing some research will set you ahead of the stream. All those horror stories you hear are because people have just gone, oh, I'll just turn up, it'll be fine. No.
As a mother who traveled with young babies, I suggest you better be well organized. You need 3 sets of clothing, and you should have your immigration papers on hand.
Yeah, exactly. For the UK parental process, sorry, Brianne, could you just repeat the question for that bit?
Yes. So how does this affect the baby's entry into the UK, the parental order, and the ability for the baby to acquire a UK citizenship?
Okay. Sorry, the first bit of that question. Sorry, the hypothetical.
If the donor is a UK citizen, is not a UK citizen, but is a legal resident, but the partner is a UK citizen.
Okay. So for a parental order process, it comes down to domicile. It's not actually to do with citizenship or official residence. You can obtain both of those and then lose your domicile. You could have British nationality, for example. I could live in Canada. I'm still a UK citizen. I would have had my original residence here. The domicile is a much more flexible concept, therefore. So neither of you have to be a British citizen nor have official indefinite leave to remain, for example, in England or Scotland or Wales, in order to apply for your parental order itself. What we're looking for is your connecting factors to England and Wales, that you have a base here, not necessarily strict residence in an immigration sense, and that you have that connection with a permanent intention to remain. So you've not just flown in and then going off to France or Germany, who are very upset with us for our parental orders at the moment, for having dealt with it, and having that connection. So residence and citizenship, great indicators, but not determinative of the actual application itself. If you've got them, though, really, I don't see why you would have much of a problem at all. And then citizenship itself, it comes back to the British Nationality Act and who can inherit British nationality and who. So it's just as if you were applying, you'd had the child here through, or one of you had given birth to the child. So you follow the rules to any other immigration matter.
Okay. We have a lot of questions, actually, so I hope you guys are... Okay, so the next one here. This is for Cindy. You mentioned 2 processes in Ontario for obtaining a birth certificate. One administrative process and one court process. Do you have to do both of them, or is it one or the other?
You can do one or the other or both. It's up to you. So,
Okay.
For example, for the UK, you can do the Statutory Declaration. It's all you need it. But I have clients who live in the state of New York and have to do a step-parent adoption, and the lawyer there will tell me they prefer the court order. I can get them home faster with the stat dec and then go to court for them while they're home. So I can do both if they want that. But I have clients who live in other countries where the stat dec is meaningless. They only need the court order. I will do the court order. If they want to get home fast, I can do the stat dec and then the court order. They can do both.
Okay. Next question. Do intended parents need a letter of comfort to enter the UK as the child is entering on a tourist visa?
I have never been asked to do one, which doesn't mean I wouldn't hand one over explaining what it is. But none of my UK clients have required it.
No, I get asked about this as well. I have to say, I, I mean, as a lawyer, I love paperwork, you know, extra bits, but it's not a necessity. Again, if you explain to the immigration official as you come through about the process and what's happened and what you've got and what you intend to do, they're more concerned about having the right immigration documents as a tourist almost, and then you are definitely going to be applying for a parental order. What they're concerned about is obviously overstayers, but you know, a baby can't exactly choose whether it's overstaying or not.
So, Andrew, is it fair to say that all they need to do when they get off the plane is show the birth certificate and passport for the baby?
Yeah. Yeah. I mean, having yeah, that and a good knowledge of what you need to do for a parental order. Yeah.
Okay. Okay, next question. If I am an EU citizen living in the UK, do I need to set my will in the UK or in my home country?
UK. Well, so I would say it depends where your assets are. If you're a UK national living in the UK, but all your assets are in Spain, then really it's kind of fine by the point because your will's going to be mostly dominated by your Spanish assets. Usually, anybody living in a foreign jurisdiction or having assets in a foreign jurisdiction should be advised to have a will in that jurisdiction for ease or probate, normally. If you are living here and you're planning on going through the process here, and you have assets here, for the purposes of supporting your child through surrogacy and meeting the debts that will arise through the surrogacy arrangement, I would definitely suggest you have a will here to be recognised both quickly, efficiently, and then can be ported across to Canada. I mean, yes, I would definitely have a will here.
Okay. Another next question. If I am an EU citizen living in the UK, do I need a parental order in the UK, or does it suffice to do a registration of my child in my home country?
So this comes back to whether you are domiciled in the UK or not. This is actually a bit of a thorny issue with lawyers at the moment. If you're domiciled and living in the UK, you're therefore subject to English laws. Sorry, I should say living in England and Wales for my profession. You are subject to English laws. It doesn't matter about your nationality, whether you are EU national, registering birth, or however you do it over there. You will need to apply for a parental order here in order to be recognised as the legal parents to that child. There is some thought at the moment, and it's one which I was discussing only at the weekend with some peers, in the sense of recognising if you're not a domicile here, then we really need to be recognising your foreign domicile wherever it may be and complying with the laws of that domicile. If it's not Canada, then you need to consider and get advice from the jurisdiction where you are domicile and where you do live habitually, in order to figure out what you need to do there to be recognised in that jurisdiction as well. Each jurisdiction is different. There is no single EU-wide policy or law which will suffice for you to just have a one-stop shop. Once you have the recognition within the jurisdiction, though, that, like, for example, getting your parental order here, then you have the running argument about being recognised under the Hague Convention for other countries within the EU. However, I suppose the long short answer is you need to get advice in the jurisdiction, the other jurisdiction, not just the England and Wales.
Okay. Next question. Have any parental orders been granted to UK parents since the legislation change in Ontario?
Yes.
Yes, I have.
Yes. Okay.
I have.
We have a couple. We have a couple questions, Andrew, that someone is going to email you directly about. So I'm going to skip those ones. So we're just going to go to this one here. What sort of assessments are carried out on the UK parents by UK authorities before granting a parental order, and by whom are they carried out?
So they're carried out by a court-appointed reporter. So when you issue your application in the UK, you will have a court reporter listed against your case. They are most commonly they're a bit like social workers, but not nearly as scary. They are actually fantastic people who really want to help you, really want to go through the process with you and understand how you've achieved your surrogacy journey and what took you through that route. Now, most surrogacy court reporters will be trained to deal with children. Obviously, they're trained to deal with a variety of children. But their key feature will be to come and meet you. They'll usually come to your house, usually in a telephone call to start with and then a visit to meet you both. Going through and seeing the environment that the child is going to be brought up in, and to go through with you your expenses and the statutory criteria I went through with you before. So all the points which you'll normally have prepared a statement and have submitted to court already, the court reporter will then go through with you and that. Their job isn't there to assess you as parents. It's not like an adoption application where you're being judged on that at a very high level skill set and threshold. What they're there to do is to make sure that you have complied with the statutory requirements and that the long-term interests and the best interests of the child are going to be served by making the court order. So ultimately, you have a judge doing an assessment with you and a judge granting you the order. The possibly most important person still remains is that court reporter who will come and visit you.
Okay, and one last question. If I am domiciled in the UK and another country, can I apply for a UK parental order as well?
It's not possible to have two domiciles. You can have two residencies, two nationalities. You can have, this is the difference between nationality and domicile. You can only have one domicile ever at a time. So you could acquire a new domicile, you could lose a previous domicile, you will always have a domicile. It's just where your domicile is. So I suppose, it's also, I should point out for the benefit of anybody who's more tax-minded, it's not the same as a tax domicile. You could have a tax domicile somewhere but be domiciled for family law purposes elsewhere. So I suppose in that sense, if you have two domiciles, that would be a question as to which domicile is the real one. Which one are you not just closely connected to, but which one do you see as your home in a singular sense? I'm afraid it can only ever be one.
Okay. So that's all the questions that we have in our question box. If anyone has any further questions for either Cindy or Andrew, they can contact them for sure. Thank you everyone for watching the webinar. The recording of the webinar will be sent to all registrants and will also be available online by tomorrow afternoon. So thank you very much, Andrew and Cindy, for joining me today and for going through everything. It was so wonderful for all that information. It was really, really fantastic. I'm sure everyone really appreciated it. So thank you very much to both of you.
Thank you, Brianne, for organizing it, and to everybody who made the time to watch, and to those of you in the future who watch it. I hope it's helpful.
I hope it's very helpful indeed. Thank you very much.
Good night, Andrew. It's time for you to go home.